SJC-09919, Commonwealth v. Brian R. Johnston.
Mr. Nathanson.
Good morning, Justice Spina. May it please the court. With me today as well is Dan Horowitz. Just for purpose of the mechanics of the argument, I intend to focus today on arguments 1, 3, and 5. I think that's the most profitable for oral argument. I know the court's read the briefs and is familiar with the record. The record is expansive. And the briefs raise 14 issues, so I'm prepared to address any other issue that the court is interested in inquiring, and I'm sure the court will direct me accordingly. To proceed to argument 1, which is the Mutina issue.
So, to set the framework here,
Yes.
your client shot the victim here, well, at least a former friend, right?
David Sullivan.
Six times.
It may have been 7.
May have been 7.
Yes.
And the defense in this case is lack of criminal responsibility.
Yes.
All right. So your first issue relates to what?
That the defendant requested that the jurors be instructed, in addition to the normal portion of the Mutina instruction, that the defendant could be held, if he was found not guilty by reason of insanity, that he could be held in a locked facility for the rest of his life. And he did that because insanity defenses, particularly in murder cases, are among the most difficult cases known to the law to ensure fairness. And that's the whole purpose that Mutina recognizes of giving the instruction, that it's a recognition that jurors need assurances because of persistent juror fears about a dangerous mentally ill person walking free. They need assurances about what's going to happen. And the argument here is that this instruction, while perhaps attempting to accomplish that purpose, ended up not being an assurance, but in fact undoing the goal of Mutina, and here's why.
So, excuse me, can I just say, yes. This is the instruction that was requested?
Yes, the request is actually set out in a tabbed portion of the brief. Yes.
So the defense counsel requested that this could be held in a locked facility for the rest of his life be appended to the instruction, and the judge agreed and did that?
No, the judge refused. The judge
would not give this instruction.
Would not give that instruction.
He gave a different one on the same subject.
She gave the standard Mutina instruction with a few other embellishments, which we also think were improper. The judge did not give the instruction that the defense counsel requested. And so the instruction that was given, by my count, lists 5 possibilities for release and omits the 1-year commitment that follows the 6-month commitment in the process laid out by the statute, Section 18, Section 16, Section 8, and Section 16. And it does not list the possibility that defendant's counsel requested that the defendant may never be released and be held in a locked facility for the rest of his life. And in fact, they were told that he would be released if he was either no longer dangerous or no longer mentally ill. And so this is precisely what defense counsel objected. This is an unbalanced instruction. You get all the possibilities for release, but not the possibility of never being released. And this court has recognized in the past that unbalanced instructions are simply unfair. This court did that in Rodriguez, in the mistrial, the deadlock jury context, pushing the jury, you have to resolve this case. In the Williams case, Williams and Bumpus, dealing with the Medeiros reasonable doubt charge. We're saying you can't hold the Commonwealth to too high a burden of proof because then the lawless would run free, but it doesn't say anything about you can't hold the Commonwealth to too low a burden of proof.
Is this the model jury instruction that Judge Josephson gave?
No. It is similar but not the same. Particularly the civil burden of proof inclusion. It is similar to the model jury instruction in 1999. This case was tried March to May of 2006. So it was the 1999 version of the models that controlled at the time, and it did not include any reference to time periods. It was just that there may be a commitment.
Does the 2013 model instruction talk about time periods?
Yes, it does.
So are you satisfied with the 2013 version?
No, for precisely the reason that I just said. And I recognize that it's a model instruction that this court has recently promulgated.
I'm not, you're not bound by it. That's fine.
Certainly, and this court has recognized that model instructions have been wrong before. Justice Spina in his Berry opinion, and you, Justice Botsford, in your DiPadova opinion. So how did this instruction prejudice the defendant? And I would point to three things. First, the jury heard evidence that would have activated these fears, which are very serious, that the defendant had been petitioned against 2 other times, the Section 12 commitment, when he was initially apprehended because he was threatening suicide on the phone to his parents. And the police actually apprehended him not because of any criminal involvement, but because of fears that he was going to commit suicide. And so they heard that he was petitioned against on the Section 12, and they never heard what happened to it. They just know that he was in the jail after that, not in a mental health facility. They also heard that he was petitioned against under Section 18, and they heard explicit testimony that he did not meet the criteria for commitment under Section 18. Then you combine that with the prosecutor's argument and questioning, suggesting to the jury that the defendant knew how to manipulate the system in order to get himself out of Bridgewater and back to jail to avoid the commitment simply because he was uncomfortable. And then the further thing that I think prejudices the defendant is the inclusion of the civil commitment burdens, which I think further pushes the jury from an NGRI verdict. And the government says, well, the jurors would have simply applied logic to the instruction that the judge did give, which is that if he is both still mentally ill and still dangerous, he will be, quote unquote, kept in the facility. Not for how long. But the government says the jurors would simply have applied logic and reached the same conclusion, and the defendant got essentially what he was asking for. There are 2 responses to that. First of all, the assurance needs to be stronger than that. And it's precisely because of what Mutina recognizes, that jurors do not behave logically when they are faced with an insanity defense in a murder case. They have trouble acting rationally. So it needs to be not inchoate logic that we're relying on. We need to have the jurors explicitly told of what may happen. The second thing is, if we attribute that level of logical deduction, rational examination to jurors, then we also have to attribute that level of examination and deduction when they're evaluating the civil commitment burdens that were inserted into the instruction. And as I've argued in the brief, what happens there is the jurors hear, well, the government has the burden of proof to prove shorthand sanity beyond a reasonable doubt in this trial. Boy, they put a lot of evidence here. Even if we go not guilty by reason of insanity, if we go but not guilty by reason of insanity, now we know that they have the burden to prove insanity at a later commitment trial, and they're going to have a hard time doing that, because look at all this evidence that we just heard. It's not what a judge would think of this instruction. It's not what an attorney might think of this instruction. It is what a layperson would think. And if we're going to attribute rationality and deduction to them, I don't see any other conclusion than they will be concerned about the inclusion of the civil burdens in the instruction. It activates juror fears. And just as an aside, the government says, well, this is just informational. The juror's not supposed to evaluate the burdens. Well, then don't put it in. And I don't believe that the civil burdens are in the 2013 model instruction. It was, obviously, it came from Robbins, and Robbins just said it's not a substantial likelihood, and in fact that it was an elaboration without basis in the law. So I don't think there's a concern about that.
Did the judge indicate in the charge conference that she was going to give the model instruction on Mutina?
The judge said that she would give you Mutina instruction.
So here's my question.
Yes.
If the judge said, did the defendant ever suggest, well, gee, then I don't want a Mutina instruction?
No, he did not. And the judge was pretty assiduous about making sure that the parties knew what she was going to give. There were draft versions going back and forth, and so it was pretty clear what was going to be given.
She gave the instruction that she told the parties that she was going to give.
Yes.
So was there a request that she not give that instruction?
But there's
Yes.
the request for the additional
Yeah,
portion of the instruction, right?
Exactly, Justice Duffley. He said, yes, please give a Mutina instruction, but please append to it this possibility that the defendant may never be released and he will be held in a locked facility.
Well, I guess my question then, let me cast it a different way. Did the defendant walk out of the charge conference thinking that the judge was going to give an instruction that was in fact not the instruction that she gave?
I don't think it would be fair to say that, no.
Okay. So why then didn't the defendant say, please, if you're going to give that instruction, I would rather have you give no instruction?
There's nothing in the record to suggest why. I mean, it's a difficult calculus, but the defendant wanted some Mutina instruction given, and it's a very difficult mental gymnastic to go through to figure out, well, what is the relative benefit? And I'm sorry.
So what's our standard of review?
This is preserved error. The judge is clear that she is not going to give the instruction not as to the civil burden. The civil burden is unpreserved. The inclusion of the civil burdens in the instruction, but it is preserved error as to the defendant unequivocally requested that he be given the language about being held in a locked facility for the rest of the life and for the rest of his life, and the judge was very clear that she was not going to give it. If there's no further questions on argument one, I was going to move to argument three, which is, as I mentioned before, is the Berry and DePadova issue. The instruction is found at pages 45 through 46 of the brief, and particularly the last paragraph quoted on page 46 is, I think, what's operative here. As I said, this case was tried before Berry, before DePadova. It's a substantial likelihood. These are substantially the model instructions.
I think, if you wouldn't mind, could we actually have you read that out loud? We have some
certainly.
foreign visitors, and they might be interested in hearing
Certainly.
what the instruction is.
The paragraph that I'm talking about says that a defendant is held criminally responsible or legally sane when he knows or in the circumstances has reason to know that his consumption of a substance will cause him to be substantially incapable of either appreciating the wrongfulness of his conduct or conforming his conduct to the requirements of the law, or both.
So the circumstances here are the defendant was under the influence of alcohol and drugs at the time? Just alcohol?
The evidence is that he drank beer. There was a tox screen at the hospital afterwards. Nothing showed up.
Other than alcohol?
And I'm not sure that actually the evidence comes from the tox screen as to the alcohol. I think it just comes from the
It just
defendant's
didn't show any drugs.
That's right.
What was the blood alcohol level from the hospital test results?
Mr. Greenbaum can correct me, but I don't believe that there was a blood alcohol level test. It was simply the defendant's statements that he drank 8 to 10 beers that night.
The issue is the relationship between whether this murder is the product of alcohol or a mental defect or a mental issue, and what the combination.
Yes, Your Honor. And so the problem is...
And the issue of whether or not the defendant knew that the consumption of alcohol would trigger a mental illness.
That was relevant.
And whether the jury understood that even if he did know, that if they found that he had suffered from the mental illness beforehand, it wouldn't matter.
Right. That's really the critical part, is that the jury is never told that a pre-existing lack of criminal responsibility is not defeated by later voluntary intoxication.
But one could, as Mr. Greenbaum argues, one could one could understand the part that you just read as saying that, right? I mean, isn't the problem that you would argue that the subsequent instructions took that away?
I would say both. I would say the subsequent instructions took it away, but I think that instruction in itself defeats it, because the jury is never explicitly told that a lack of criminal responsibility is not defeated by voluntary intoxication.
Right.
And so we're confident that it's a technical exercise, but I'm confident that if the court compares the instructions, you will find the same error.
But it sounds as though what you're asking for is an oversimplification.
I don't think.
I mean, there are times when voluntary intoxication will defeat a mental and insanity defense, won't it?
Yes, it will if the defendant is not already lacking in criminal responsibility. Yes. Okay. But there is evidence here. Maybe I should just similarly get to that. Is that the defendant did lack criminal responsibility even when he was sober, which is the testimony of Dr. Kelly, the testimony of Dr. Feldman, the testimony, the civilian testimony of his running into a police barracks on the turnpike and saying, help me, they're after me. There's nobody there. On the beach in St. Martin, and becomes very upset that somebody from Hawaii has followed him all the way to St. Martin. There's nothing to indicate that that's true. He becomes very upset that his father is going to, yes?
Yeah, so he has a history of delusional behavior.
Yes.
And what was the evidence of delusional behavior on this occasion of the murder?
Well, the evidence is that he thinks that David Sullivan is part of a conspiracy to harm his family and himself, that there is some sort of cabal. It's very difficult to understand because it's not rational. There's a cabal between the Irish mob and the Korean mob and the CIA. It's very difficult to really understand. And I think part of the problem here is that we're trying to make sense of something which the defendant says he doesn't understand. He's trying to figure out why these people are after him.
Yeah, and there was evidence that he was under that delusion or under that, operating under that state of mind at the time of the murder.
Yes, he says, I'm not sorry David is dead. I was his prisoner. He says that when he called him, that day he walked out of a class at Westfield State, and that he saw David Sullivan smile at him in some sort of significantly eerie way, sort of threatening.
And he wasn't supposed to be on that campus, right?
David Sullivan didn't go to Westfield State.
Right.
He went to UMass. And that when he spoke to him on the phone, he wanted to find out what happened in Albany. He has this delusion about he was raped in Hawaii, and that David Sullivan said something in Albany that indicated that he was involved in having him raped, and the rape had something to do with the Italian mafia and his treatment or perceived treatment of Jessica DiGirolamo. It is a very tangled web.
Now, all of this comes out in what context? These are post-murder interviews with his psychiatrist?
Well, what I'm talking about, the delusions on that night?
Yes.
Most of them, yes.
So these are post-event statements that he made to his examining psychiatrist?
Yes, but there's plenty of evidence that the defendant had these delusions well beforehand, and that David Sullivan was a central part of them.
But did the jury hear testimony about the delusions that he was experiencing on the day of the murder?
Yes.
All right.
Yes. And as to the defendant's behavior while sober, you'll recall that there's a witness, Ed Arisimovitz, who was in Hawaii and did lots of drugs with the defendant in Hawaii. Back in Massachusetts, at a later time, he says to the defendant, is that real, or is it just in your head? What's going on, Brian? And the defendant becomes very upset. And he says, you just don't fucking know. This is a defendant who was tortured by delusions. It is a tragedy what happened to David Sullivan, but Brian Johnston had a very substantial lack of criminal responsibility defense, and the instructions and the conduct of the trial in this case cut away at it. If the court has no further questions, I'll rest.
Thank you.
Thank you, counsel.
Good morning, Your Honors. Stephen Greenbaum for the Commonwealth. I'd like to make two preliminary points. One, that the other issues raised by the defendant, aside from the instructional issues in here, largely were raised in the motion for new trial, and I would refer the court to the motion judge, who was the trial judge's lengthy memorandum, and in particular the fact that she did not credit lead trial counsel's affidavit on those issues. I think the other part in considering this case is might not sound that way, but the Commonwealth, in fact, had a strong case for sanity in this case. As Justice Corder, you mentioned, the defendant's statements about what went on that night and his phone call with the victim, were made sometime later to his own counsel. What happened to his own examiner? The evidence, what we did have, there's no evidence of what went on in that conversation that night, other than prior to calling the victim, he called 2 or 3 other friends to wanted to go out and socialize, and accordingly, he apparently called the victim because he wanted to go out and socialize. And we know at the time of that phone call, his neighbor upstairs heard him screaming and yelling in what sounded like an argument on a phone conversation. And then he went ahead, drove up, shot the defendant, drove back.
Did he leave a message for his sister?
That came later.
Okay.
That came later after the murder. Right. Drove back, hid his gun in the woods, removed the clip, emptied the chamber, got stuck on a log, unfortunately, managed to negotiate his way around contact with police officers by telling them he'd gone to a party at UMass, that he'd just been drinking.
Are you suggesting that negates insanity, or is there?
No.
Okay,
no.
Because there seems to be a
No, we're not suggesting that negates insanity, and on that, not at all. And on that issue, 2 parts, I'd say. On the issue number 3, the Barry DiPadova issue. Mm-hmm. The evidence certainly indicated that the defendant, something happened, traumatic happened to the defendant in Hawaii. And there was a lot of evidence that it was connected with his immersion in drug culture and drug dealing and drug use. He may have actually suffered delusions and hallucinations. Some of the experiences that were called delusions, such as this being raped while under drugs, may in fact have been real. We don't know. So he suffered traumatic experiences in Hawaii. We know that. We know he also was using drugs heavily. When he came back, there were certainly episodic periods when he was with his friends, he would be talking about the horrible things that had happened to him in Hawaii and his connections with the mob, or how the mob was after him, and various slightly different versions of those. But it wasn't all the time. For the most part, the defendant lived a high functional life, going to school, holding down this very responsible, difficult job as a security officer at a hospital, in which he was brought into contact with the very sorts of people and situations where you would have assumed that whatever mental illness he had would have sent him over the edge.
When you focus on, you've got evidence both sides. You've got evidence of insanity, of maybe not. Doesn't this complaint of instruction really tell the jury, if hey, you have to hold him criminally responsible if he knew that,
Well, our argument
drinking
is that the instruction doesn't say that. The first thing we've pointed out is that the paragraph read here today by defense counsel, and that is a paragraph in the instruction here that given by the judge here, and is the only instruction given in Barry and DiPadova. They're different instructions. The only instruction given in Barry and DiPadova about the interaction is this one paragraph that talks about subjective knowledge and its effect. This instruction is different, and I believe it might have been a model instruction at that time, but I could never find the model. This instruction starts off explaining that the baseline is someone whose mental illness is activated by alcohol or drugs is still not criminally responsible, is not criminally responsible. And I think that's important. The defendant may well have suffered from a mental illness all this time, but there was no evidence that he ever was pushed over to the edge to lacking criminal responsibility unless he was using alcohol and drugs, which is a difference. This is it's the whole activation theory. You can be mentally ill and harbor delusions, but manage to function and not engage in wrongful conduct. But you may know, or it may happen, if you're being, that by taking drugs or alcohol, that pushes you over the edge into acting on your delusions. And that's what that instruction is about, the Hurd instruction, I believe, is about.
So you're saying here that there was no evidence that he had been not criminally responsible prior to the night of the shooting?
Correct. There's no evidence that his mental illness had ever rendered him such that he didn't appreciate wrongfulness of conduct or
But that's generally the case unless a defendant has committed other crimes. I mean, the issue is whether he was mentally ill, right? I mean, unless you commit another crime, how are you ever going to have evidence that somebody didn't appreciate the wrongfulness of his act?
If we go back to Berry and DePadova, and I think the court's concern there is both defendants in that case had long-standing histories of severe mental illness, numerous commitments for schizophrenia, whatever their other serious mental illnesses were. This defendant had none. In the time period immediately preceding the murder, he had been seeing a psychiatrist for anxiety, or a psychologist. He told him about his anxiety stemmed from what had happened in Hawaii and referred to that, but he made no mention of being involved in enmeshed scare.
Are you suggesting that these are all made up delusions? Is that what you're suggesting?
No, not those delusions, the paranoid expressions were made up, but that the Commonwealth's suggestion was that after the defendant realized he'd killed someone and came home, and after this happened, that he basically played up his delusions and attributed it all, his killing, which the Commonwealth's theory was a motive for anger at yet another one of his friends who had turned away from him and rejected him because of his delusional but difficult behavior. And then afterwards, he played up his
Well, you may very well be right about
conspiracy.
that, but isn't that a question of fact for the jury?
Yes.
And isn't the jury entitled to weigh your view or the Commonwealth's view of the evidence against the defendant's view of the evidence? It seems to me what the defendant is saying is in the process of weighing that view, they should have they should be properly instructed. And he's saying that they weren't properly instructed.
This is, I think, the crux of that issue, is the difference between the single paragraph given in Berry and DePadova and this paragraph. This instruction, which encompasses about 5 or 6 paragraphs, establishes a baseline, that consumption of alcohol that activates a mental illness, and it's not clear what that means. That doesn't eliminate the possibility, that doesn't remove you from being criminally responsible. That's the baseline the judge told them. A person who consumes drugs or alcohol and activates the mental illness such that they lose substantial capacity is still lacks criminal responsibility.
So if the jury believed the defendant's view of the evidence as to mental illness, if the jury believed him, he's saying that the instruction that was given would have drawn them away from a finding of not guilty by reason of insanity. Tell me why that isn't the case. He's saying that the instruction would have drawn the jury away from concluding a not guilty by reason of insanity. It wouldn't have permitted the finding.
That would require a review. It's possible. That would require a view of the evidence that the defendant, at the time of the murder, had a mental illness that had already sent him over lacking substantial capacity, and that he did drink that night and therefore it happened. Commonwealth's position is there's no evidence that he ever engaged in conduct over, and that's what the Commonwealth expert ever engaged in conduct over the line unless he was intoxicated and or using other drugs. But yes, and that's not the evidence that was important. The defendant's case was, and the defendant's experts' positions were that alcohol and drugs had nothing to do with his mental illness or his conduct. They said there's nothing. Neither of the experts gave any significant part to his drinking that night, which is another part of the case that needs to be considered in their posture here. Neither Dr. Kelly nor Dr. Feldman felt that intoxication or cocaine use and whatever else had any role in his behavior, and it was all due to this delusional disorder. Dr. Wellner's position was, look at his conduct that night. It showed his ability to appreciate wrongfulness. It showed his ability. So the Commonwealth's case wasn't that he he had the subjective knowledge which voided his right to the criminal responsibility defense. It's that his conduct showed that he was responsible that night, that he showed appreciation of wrongfulness, and he showed an ability to conform his conduct that night.
Should we be looking at the evidence to see if, and I take it this is what you're saying, the defendant's defense of insanity had nothing to do with intoxication? There's no evidence that he had either consumed drugs or alcohol on that night.
Well, there was evidence he consumed alcohol that night, and the Commonwealth's Commonwealth's theory is, experts' theory, and the Commonwealth's theory is that his behavior that night was fueled by his steroid use, which contributes to his steroid use, which had been ongoing, drinking, and perhaps cocaine, that this was basically a roid rage type incident, and that given his history of aggressive and belligerent behavior when intoxicated, he got angry that night and went out in anger, not in delusion, went out in anger and killed the victim.
No evidence of cocaine, right?
No evidence of cocaine that night.
How about steroids?
The evidence was that there was no evidence of steroids, but there was testimony.
So that was but it was still the Commonwealth's theory? It was still the Commonwealth's theory, even though there was no evidence
there
that
was
either was used?
There was testimony that the effects of the steroids go beyond the actual usage. There was talk about the cycling, and you taking steroids in cycles, and the negative effects of the steroids go on after you've taken.
And some potentially maybe inappropriate testimony about moon face or something.
Well, that wasn't
was related to ostensibly.
That was related, but the steroids were found in his apartment, and his friends knew. He had told friends he was using steroids. That was not in dispute.
Was the Commonwealth relying on the voluntary consumption of either drugs, alcohol, or steroids as a trigger, as a
Commonwealth's
trigger known
position
to
was
the
that
defendant?
he didn't have a delusional disorder working that night. While he might have had a sufficient delusional disorder which robbed him of his substantial capacity that night, that he may have been given paranoid expressions of behavior periodically over the previous 2 years, but his conduct and his belligerence and his use of the gun that night was related to the steroid use and perhaps fueled by the alcohol at that time.
Are you saying that steroid use is not something that can be considered as a trigger of a mental illness? It can only be drugs or alcohol?
No, I'm not saying that, and I don't think that issue came up or the experts said that.
Okay.
Really, the Commonwealth's position more is there's not, while there may be evidence of mental illness, although we suggest maybe not, his conduct that night, let alone the steroid use. He was acting in roids, but his conduct that night indicated he had the capacity. He didn't lack substantial capacity either to appreciate his wrongfulness or to conform his conduct. So it really wasn't a battle between was he mentally ill and was it negated by drug use, but was he criminally responsible?
Was he delusional that night?
Right.
Was he acting out of delusions,
was he
or
acting
was he acting out of rage?
delusion? Or was he acting out of rage because he was mad at his friend?
That was the
But
issue.
even going back to this instruction, I think I would really urge the court to look at the differences between the instruction in Berry and the actual instruction given here, because where the judge if this is an issue, the judge laid down the baseline that drug and alcohol consumption keeps you criminally responsible, and laid out the knowledge exceptions, none of which are someone who is already mentally ill and lacking capacity, who knows that somehow.
But the step that's missing, I haven't read this record, so it may not matter, but it seems to me that the step that's missing is that even if the person suffers from a mental disease or defect, and it's activated by the consumption of alcohol or drugs, if they're already suffering from it, even if they know that it gets activated this way, it doesn't matter. You don't lose it, right?
This is the problem with understanding what activated means. My understanding, having watched the Berry arguments, this is a nuanced and difficult area. My attempt to understand this is that by activation we mean someone suffers from a mental illness, has it, but it's either controlled or not so serious that they engage in wrongful conduct because of lacking capacity. It's activated by taking some alcohol or drug that then pushes them over the edge to lose control. That's what activation is. I'm thinking, I believe what Barry's talking about is exacerbation, someone who already is mentally ill and lacks substantial capacity and only gets worse. Sort of like what they said in Barry is like, it only gets worse. And I think what the court noted in Barry is like that it was possible. Well, I'm going to stop there.
Well, are you saying that do you agree that, I'm going to give you two choices here, and are you saying that the instruction was incorrect, but it doesn't make any difference because it doesn't cover the facts of this case, or are you saying that the instruction, the complaint about instruction here, was a correct instruction?
I hate to say somewhere in the middle. The instruction does not, I think the instruction was adequate, if I can use that word. The instruction did not say what Barry says ought to be said very clearly in order to avoid juror confusion. It didn't say that if you believe the defendant was mentally ill and lacked substantial capacity, then his use of alcohol, which might have made his conduct worse, whatever this, does not moot the insanity defense. But I think this instruction, given the initial instruction about consumption that activates, whatever that means, and that not removing the criminal responsibility defense, it removed, so reduced the likelihood that a juror would interpret the law to be that the voluntary consumption voided the defense. That's the bottom line there. That it doesn't have the inadequacies of Barry, which was too minimal. It doesn't explicitly say what after Barry the court said should be said, and this trial happened four years after Barry. But what it does say would not permit a reasonable juror to conclude that his consumption of alcohol that night would have voided a genuine criminal responsibility defense. Oh boy, it took me a long way to get there, but that is sort of the gist of the argument we have on argument number 3. I'm not sure elsewhere what other issues the court would.
Well, the Mutina instruction, maybe you could.
Our argument is simply that the court said the defendant will be initially can be initially committed for evaluation. As someone who's found, not the defendant, someone who's found guilty by reason of insanity, not guilty by reason of insanity, and can be petitioned to recommitted. The court decides, and that as long as the defendant remains mentally ill and remains dangerous, they are kept in a locked facility. A person understanding that would say, well, that could be for the rest of his life.
Isn't there a time frame in there, 6 months, that was added?
Well, I think the judge mentioned the initial 6-month period, and she said, periodically, a court reviews the order of commitment. She didn't say every year. She said periodically. I think that's close enough to the fact that they're one-year commitments that the same message would get across, that if the defendant, if an NGRI defendant is still mentally ill and still dangerous, he or she stays in there until he's not, which is
so you're saying, and I take it implicitly, if not expressly, implicitly, the jury would likely have known that a defendant could have been incarcerated for the rest of his life.
Yeah, or confined.
Or confined.
Yes.
Confined.
And I don't quite recall the sidebar, but I think part of the sidebar discussion when the defendant requested that instruction was the Commonwealth saying, well, then you should instruct them that he could be released after a year, because that could happen too. And rather than get into the whole problem of, which Mutina said, of predicting outcomes and having jurors get involved in predicting the outcomes, you just want them to focus on the case. As for the civil commitment standard, that apparently was in, we stand by the argument of Roberts that this is an accurate statement of the law and didn't create a substantial likelihood. But it appears that it was actually in a model instruction because the defendant's request is using a model instructions. I don't know. Again, that doesn't make it proper, but would stand by the argument that didn't create a substantial likelihood of miscarriage.
Thank you, Counsel.
Is that my time? Yeah.
Yep. Thanks.